proceeding, just like an eviction proceeding. Massachusetts tends to be very particular about it. If you file that proceeding and you forget to attach your 14-day notice, you're not going to get a hearing. And they'll tell you right up front. If you file the proceeding with your 14-day notice and you forget to list one of the lessees on the 14-day notice, but you list them on your summary process complaint, your case is dismissed. You have to get the spelling exactly correctly. So they're very, very particular in Massachusetts. I tend to think they're somewhat pro-tenant, more so than on the landlord side. So assuming that everything is in accordance to their requirements, you go to housing court, you'll get a hearing date, probably within several weeks. So it's similar in Rhode Island. You try and get in as quickly as possible because the key is not to have a landlord aggrieved for non-payment of rent. When you go to housing court, you're not in front of a judge right away. You need to go through the mediation process. It happens more so where the tenant shows up without an attorney. So just like we discussed several weeks ago, the mediation process alleviates a lot of the litigation before the judge. The goal in the mediation is to either come up with a payment agreement so that there would be a way for both the tenant and the landlord to be satisfied. Maybe they'll get additional time. So you can come up with a payment agreement, you write up a stipulation, it's got to be approved by the judge. You may set it down for a review date several weeks later. If the payment agreement is not abided to, then the landlord has right to go forward and seek an execution. Your execution, similar in Rhode Island, which is your right to actually evict the tenant. And if you have an execution date and the tenant's not out, unfortunately what happens is they literally, physically remove the tenant. So you would have to get your execution. That's your piece of paper that says, tenant, you're out, according to the judge, according to the court. It goes to a sheriff, they hire a moving company, and they take everything out of the apartment. And if you refuse to leave, they'll pick you up and take you out. That's just in the form of non-payment of rent. Okay.
Just to elaborate on that too, the execution process is very similar in Rhode Island, but what Jackie says is very, very rings true in the sense that judges are very detail oriented. They will pick apart the 5-day letter that I was telling you about. If the amounts of the rent that are owed is not exactly correct at the time that the letter was sent out, if for some reason the name is spelled incorrectly, as Jackie indicated, or you have somehow the letter was, you have the person's last name correct, but somehow the first name or not all of the tenants are listed. All of those things are very, very small little minute details where you would think that that is not such a big deal, but cases are actually thrown out on those bases. So even though the process, at least in Rhode Island, seems to be fairly simple to evict someone for non-payment of rent, you have to really make sure that all your I's are dotted and your T's are crossed, otherwise it will be thrown out.
So if that's happening though, suppose there's not a contract, suppose they're leasing or renting month to month, and this 5-day notice comes, does the tenant have some recourse about saying, but I have plumbing that's leaking and this isn't happening, and that you have some breach of what your good faith, good condition of the apartment or house or whatever is? How does that work?
Just before I answer that, I want to add to what Lenny mentioned about particularity of judges. There are particular judges that request a copy of the deed to the real estate because they want to know that the person before them is actually the owner of the real estate. So if Mr. and Mrs. Davis own the real estate, Mr. and Mrs. Davis better be in court.
As opposed to
the lawyer? My grandma. Oh no, if there's an attorney, that's different.
Okay.
But if they're there on their own behalf,
okay,
they want to make sure that Mr. and Mrs. Davis are present. And even in some cases, they should be present in court with their attorney. And if there are some judges that actually dismiss the cases if they're not there. The other thing too is if Mr. and Mrs. Davis have house on 123 John Street in a corporation, Mr. and Mrs. Davis cannot go to court and represent themselves in Rhode Island, because Rhode Island has this cute little law that says if you're a corporation, you can't represent yourself, you need to hire a lawyer. So a lot of landlords come to court thinking, I want to represent myself, I don't want to pay the legal fees, and the judge says, you're a corporation, I'm sorry, I need a certificate of authority giving you the ability to operate as a business in Rhode Island, and we have a law that says you have to have a lawyer.
Okay, before we go back then to that question that I was about to ask, does that mean that it's almost impossible for a landlord and a tenant to represent themselves? Do they always have to have a lawyer? I understand there's attention to details, spelling names correctly, crossing T's and dotting I's, but is this kind of a situation ever a do-it-yourself situation for a lawyer and for a landlord and tenant?
Well, certainly you can do it yourself. Jackie and I have seen time and time again people go in and they represent themselves. However, that being said, given the details that are necessary to make sure that everything gets done correctly, you're strongly advised to have an attorney. The only people that I see that are typically successful that represent themselves, usually in a landlord setting, are people that have done this before and have gone through the process and have learned through their mistakes.
Yeah.
And unless you're, and like Jackie said, if you're a corporation, there's no ifs, ands, or buts about it. You need to have an attorney present. Not just, not to get off track, but that law also applies in every court.
Even in small
the
claims
district.
court.
Yeah, small claims, any court. If you're a corporation, you need to have an attorney represent you.
That's
Good
just
point.
in Rhode Island. That's just in Rhode Island.
Yeah.
Okay, so
Getting back to the other
reason,
reason, tenant decides I'm not going to pay rent, and landlord says I want my rent. They send the appropriate notices. They file a complaint. They file in Rhode Island. They file their eviction complaint. Tenant has the right to file a counterclaim. That's their answer plus their complaint against the landlord. What is the reason why they were not paying rent? Well, there could be a few reasons. For instance, the plumbing's not working, the refrigerator broke, my boiler broke. If that's the case, they do have a right to withhold their rent. However, they need to put the landlord on notice, and they need to give the landlord the ability to come to cure the problem. Now, if it's a boiler, especially in the middle of winter, the landlord can't wait until May 1st to fix the boiler.
yes, that's
So it has to be done immediately, okay? And in some cases, if it's not done immediately, then the tenant can take it upon him or herself to fix the problem and appropriately deduct it from the rent. However, they need to put the landlord on notice. So in this case, assuming the boiler's broken, or let's assume that, there's a wall broke, okay? Is it something that needs to be fixed immediately? It should be fixed, but it isn't. There's a leak in the roof. They need to put the landlord on notice immediately that they're going to be withholding their rent because of problem A, problem B, and problem C. We advise as attorneys that that needs to be put in writing.
Absolutely.
Don't just call up and say, I'm not going to pay my rent because my toilet's running. You need to put it in writing. Okay, it's always better to have it in writing because it's going to come up later on.
That's a bottom line for
Yeah, put it in writing.
Yeah.
Now, if they're going to withhold the rent, that means the tenant needs to keep the rent in the bank account. Okay, you can't go and spend it on something else. It needs to be preserved. So once the problem is fixed, then they can release the rent. Okay? Now, if the problem isn't fixed and the landlord insists on going to court and filing an eviction action, that's when the tenant has a right to file a counterclaim against the landlord, probably for breach of warranty of habitability, which is when I rent from you, I have a contract with you, landlord, that says I have a right to enjoy my living space. I have a right to make sure that it's habitable. So you can file a breach of contract action. You can put in there that the apartment was not up to code, whatever it is that you, as the tenant, decided to hold back the rent. You also should attach a copy of the notice that you gave to the landlord. Then you have an action in court that can be addressed. So when it comes time to have your hearing, the judge is most certainly going to know why you held back your rent. The judge is going to know if you put the landlord on notice. Is the rent available for payment? So there are mitigating circumstances here, and it very well may be that the landlord will not be granted the eviction because it may be a justified reason for the tenant to withhold the rent. And it's similar in Massachusetts as well. It's similar in Massachusetts.
Do you find that there are many people who have worked the system by having these kinds of complaints, whether they're legitimate or maybe I accidentally took a wrench to the, I don't know, accidentally took a wrench to the pipe and I can prolong my rent payment because I lost a job or whatever, for whatever the reason. Do you find that there are other reasons for people challenging this, or that there's much challenging of that?
Well, when you say, you know, whether I
You're
mean, certainly,
smiling.
I'm smiling because we've gone through, I'm sure, many, many stories. We
Seen
could
them
sit
all.
here, yeah, we've seen quite a bit of it.